Hi, everybody, and welcome. This is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and welcome to Raw Law. This is the show where we answer your questions and we talk about your comments. And the beauty of it is we're here live, so we can answer all your questions, interact with you, and give you some valuable insights. So let's get into it. Let me go to the first question. I'm sorry I'm a little late. It was a crazy day today. We were very busy. I had a lot of meetings and I had to actually shoot some videos, some of which were for this channel. One of our editors, Aiden, was here. So we were shooting videos and I got a late start and court and clients and this and that. So it got a little busy. And also on top of everything else, they're fixing our roof in our building. So there was a lot of banging, and I didn't want to do the live during the roofing because it would be banging on the roof. But now they're done, so it should be nice and quiet. Yeah, so let's get into it. Let's see. Manny says, "Hello, Arkady. Question I asked my attorney: how much does the commercial truck have in insurance? He said 1 million and 5 million extension. I asked how much are we shooting for. He said he will present the case to the entire firm and or a focus group to develop the range we should be targeting. Do I qualify for the 6 with a 2-level ACDF, a rotator cuff, and a bicep tear and a neck discectomy surgery?" I mean, yeah, I think so. I mean, I don't see why not. It's a serious injury. It's a very serious injury, so you should qualify for everything. I think you should qualify for the entire amount. I don't think that's really the kind of case where you need a focus group. I think that's the kind of case where you just ask for an amount that's greater than the limits. I mean, what I would do is I would send them a settlement opportunity letter, maybe say, look, pay me the 6 because that's all you have. So this is your chance, right? And it's your choice to now resolve the case within the available insurance limits, which is 1 + 5, right? So 6. If you do, we have a settlement. If you don't, I'm going to go to trial. But guess what? At trial, I'm not going to be saying it's worth 6. I'm going to be telling the jury that when you match up the law and the evidence, civil justice in this case is perhaps 10, right? Or much greater than you have. So then what if the jury agrees and gives me 9, for example? Who's going to pay the other 3? Who's going to pay it, right? It's going to be the trucking company. Are we going to have to liquidate their trucks? Are they going to go out of business? Are they going to have bankruptcy, collections, right? Put the pressure on them. Because remember, the policyholder, right, and the insurance company, there's 3, it's basically like a triangle, right? You have the policyholder. They're just the trucking company that's buying insurance and paying premiums. So they're, let's say, at the top of the triangle. At the bottom of the triangle here, you have the insurance company. And on the other bottom of the triangle here, you have the defense lawyer. And see, they all have a little bit different interests because the defense lawyer wants to bill, make more money. The insurance company over here wants to get rid of it, wants to pay you, pay the lawyer as little as possible. And remember, the biggest relationship is between them and their policyholder up here, right? Between them and the insured. And they have a duty of good faith and fair dealing to their insured, to their policyholder. They can't leave their insured out to dry. That's against all the good faith insurance laws, and that's the definition of bad faith, right? Leaving your insured, who's paying you premiums for protection for insurance, out to dry and getting them hit with a big verdict, right? So that's when you have to be able to know that, understand that, and really make those arguments and explain to them why they have to pay. So I don't know if you have a trial lawyer or a real trial lawyer, they should be able to do that. If they're not, then just text me. I'm happy to help. But yeah, the 2-level ACDF, rotator cuff, bicep tears. I don't know where you're located, but yeah, that's easily a tender or really, really close. Okay, and then I'm a Beam says, "Hi, Arkady. On August 14th, I have the last settlement conference that I have to appear to. If we can't resolve the case during that, how long would it take for this case to go to trial in Nassau?" Okay, yeah, so April 14th, you have the settlement conference. Okay, And then you're saying how much longer. So I would ask your lawyer, it depends on when you filed the note of issue. So it's usually from that date. But I believe in Nassau, it's not too long. It's usually like about a year from the note of issue. So there's no real calculation from the settlement conference because, it's up to the court. They could schedule a settlement conference early if they think it's going to lead to fruition, like to a settlement. But if they might never schedule a settlement conference, or they might schedule one later, closer to trial, or there might be multiple settlement conferences. So I wouldn't be able to tell you like how much longer from the settlement conference, but usually from the note of issue date, it's like about a year. So you could look on eLaw or eCourts, and it'll tell you your note of issue date. That's when your lawyer certified the case was trial ready. And from that date, it's about a year. So, I think maybe even less than a year, but about a year, Nassau County. Nassau County is a good county for efficiency. They're quick. The bad thing about Nassau County is the jurors are a little conservative. So you have to really have somebody who knows how to select a jury and how to get off people who cannot be fair for cause, right? Because you have unlimited cause challenges. That's critical because otherwise Nassau County could go really bad. Like I heard about a case where a lawyer had a fusion case and they thought it was going to be like, $5 million, whatever. And it was like a $20,000 verdict. So Nassau County, you have to be careful. Okay, Joe Sweeney says, hello, sir. Is it bad to send the demand letter before surgery? I have the surgery date. It's about 2 months away, but I was hoping to get the ball rolling. Yeah, I mean, I would wait for the surgery, of course. Yeah, wait for the surgery, get the operative report, then send the. And remember, it's not a demand letter. I don't like the word demand because demand is like I'm demanding, I'm begging, You're not demanding anything. You're the injury victim, right? Forget about the word demand. It's a settlement opportunity. You're giving them the chance, the opportunity to pay you the policy limits. If they don't, then that's their choice. Then you go to trial. And guess what? Then that opportunity expires. It goes away, right? It disappears, just like any opportunity. If you have the opportunity to catch a train and it says the train is at, 6:22 p.m. and I'm running, and guess what? The door's closed and the train's left the station because it's 6:23 now. Well, the opportunity is gone. I can't have to wait for the next train. So that's the whole point, right? You're giving them the opportunity. If they don't pay you your number, then it's going to go up because you're going to do trial prep. You're going to get more experts. You're going to do demonstratives. Like today, I was on the phone with a company. We're doing a big demonstrative for an animation reconstruction with a brain injury. We said, look, pay us $5 million. Our opportunity is still open. I think it expires May 9th. But if they don't pay it, we're going all in. And it's not going to be $5 million anymore. It's going to be like $15 million. That's the way you got to go. That's the way I'm trying to tell everybody. Don't demand anything. Demand is like, I'm begging you. Don't beg them. Have them beg you. That's the way to do it. Okay. Faded says, got a $500K offer for my spinal fusion accident. That's the insurance limit. My attorney advised declining since there may be excess coverage through Chubb. Was this the right move or should I have taken? Well, I mean, yeah, like you have to find that out. I mean, they can't really give you an offer before telling you the insurance, right? It's like everything has to go in order. It's kind of like saying, do you want to buy this house? But I'm not going to let you inside. It's like, wait a minute. First, they have to tell you how much insurance they have, right? The primary and the excess, including all the layers of umbrella. And then once you know everything, then you tell them how much you think it's worth, right? That's the settlement opportunity. And then they give you the offer. But by them giving you the offer now, it's almost like they're trying to get you to agree, right? $500,000, I mean, it's serious money. But for a fusion, but if you don't know if there's excess or umbrella, what if there's $5 million excess, right? So then it could be worth more. It could be worth 4 or 3 or 5, right? 5.5. So why would you agree to take $500K? So yeah, I mean, I would just, of course, find out what the insurance is. But really, they should tell you first. With Chubb, it's a good chance, a good likelihood they have more insurance. Like the last case they did with Chubb, they had 25 million excess. So Chubb, writes big policies. So definitely find that out. And then, and then you make an informed decision because, you don't want to be leaving like $5 million or more on the table. That's crazy. I don't even understand like how people could do that. It's crazy. It's a lot of money. It's like, why would you, of course, yeah, because a fusion is a serious injury. Okay. And then, Jeannie says, I have a deposition coming up, New Jersey, in Essex County. Do settlement talks usually happen at them? I mean, not usually at the deposition. At the deposition, what happens is they ask you questions about what happened, the liability, and then your damages, like all the injuries you sustained, things like that. That's usually what happens at the deposition. And then, oh yeah, some people talking about being late. Yeah, I'm sorry about that. It's stuck in court. But Joe says is hardworking, and I appreciate him looking forward to these things. Oh yeah, no, absolutely. Yeah, I'm happy to help. Yeah, absolutely. Next time I'll do it. I'll make sure it's on time. Today was just a little crazy, too many meetings and things. Okay, Marquita says SI joint fusion in January from the grocery store fall over beer boxes. Oh yeah, we talked about this case in aisle. Plus found out about late diagnosis of fractured patella, and there's a patella surgery, a patelectomy last week, all linked and documented. Can the claim increase? Yeah, absolutely. Absolutely. It should be much more. And then my lawyer said she hasn't been updating me on my case because she has to focus on clients who pay her by the hour. Is this fair to me? She shouldn't have taken my case. Yeah, I mean, yeah, that's nonsense. I mean, if they're taking the case, then they have to like answer your questions and communicate with you. They can't say I'm taking other. First of all, if you're doing cases by the hour, that means you're doing something like real estate or immigration or criminal defense. So that means already that's not a good sign, right? Because somebody who's good at personal injury only does personal injury, only does civil justice, and they're like a certified trial lawyer only in personal injury. Now, if they're doing like something by the hour, what can you get by the hour? Real estate closings, immigration, I'll write your immigration petition, give me $1,000, whatever it is. Criminal, I'll go with your DUI, I'll go to court, I'll get your DUI dismissed, give me $1,000, whatever, 5,000, whatever they charge. But that's like, what does that have to do with you? That's like just like, I'm busy. Okay, sure, but they have to answer your questions. And I remember I tried to help you find someone, right? I remember this case, but then maybe that lawyer wasn't available. But then I tried a second lawyer. I don't know if the second lawyer worked out, but just text me privately, and we'll chat about it. Because the second lawyer I think that I recommended for you is a really good trial lawyer. So maybe he could help. Okay, and then she says, my lawyer says Publix blames me for getting up from the shopping cart and won't settle, but she won't file a lawsuit. She said she's trying to avoid that to save me money. I think she doesn't have the money. Well, yeah, that's nonsense. I mean, first of all, look, if they're not paying you because they're saying it's your fault, then how is not filing a lawsuit going to accomplish anything or save money? Because the whole point is if they're not paying, they're considering it either as a no pay, which is zero, right? So zero is obviously nothing, right? Or sometimes they'll give you nuisance value, but nuisance value is like $3,000, $5,000 or less. It's like just go away, like you're a nuisance. Here's some $1,000, whatever. But you don't want either of those options, right? So the only other way is to go to a jury and present the case. But I know the issue in your case. See, the problem is in your state, even if they find you, I think like a small percentage at fault, right? Then you can't recover. So you have to find, I think, the Publix, so the defendant, like all the fault has to be on the defendant because it's like a contributory negligence state. That's what one of the lawyers explained to me. So that's the way the law works in the state. But I think I don't see how it's your fault if you're in a mobilized like wheelchair, and then the aisles are like blocked off, and then just the fact that you get up to get something from the aisle, like a drink, that's not negligence, right? Negligence is the failure to use reasonable care. But that's what a reasonable person would do. If a reasonable person is sitting, let's say, in their wheelchair, in their motorized scooter, and everything's blocked off, they have these displays, these towers of whatever it was, beer or whatever drinks. And then how are you going to get your item? You have to get up. You're able to walk, right? It's not like you have a scooter, but it's not like you're incapable of walking. Obviously, you can walk. So you get up, you get your item, and you go back to your scooter. But you should be able to get up without having tripping hazards in blocking the aisle. So I don't really see it, but everybody could see things differently, and I don't know all the facts, but I don't really see a problem with that. I would take that case. I think it's a good case. Okay, CC says, arthroscopy on the shoulder and nerve ablation, C2 through C6, what's the value? Yeah, I mean, that has value. I mean, I couldn't really tell you because I don't know like where you are, what the liability is. Remember, all these things. Like if you really want to know the value, I would need to do like a full consultation, and you could text me. It's 347-566-9595. Because in order to really find out the value, if you watched any of my videos, you have to like analyze all the different components, right? First of all, what's the liability, right? Who is at fault? How much insurance is there? Where are you, right? Are you in Bronx or are you in like Oklahoma? It's a big difference, right? In the Bronx, it could be worth 5 million. In Oklahoma, it could be worth like less than 500,000, right? So like all these factors, then how's the case being prepared? Is there a trial lawyer on it? All these things I have to really speak to you. I mean, I can't really give you a value I can tell you what injuries I've settled these injuries for, like arthroscopy on the shoulder. I've settled that anywhere from 150 up to like I've settled some arthroscopies if they're serious with anchors for even 650, and then nerve ablations. Sure, I've settled those also, like some for smaller amounts, like 100, 150, but some nerve ablations I've even gotten much bigger numbers, like if you count, I mean, ablations, if you count them as like pain management, I've even settled some pain management cases for more than 500,000 just for the pain management. So there's a range there. Okay, Susan says, hi, Arkady, love these videos and live streams. I was recently in an auto accident with a commercial car truck. The ran the red light and T-boned my car, which is totaled. I have 3 herniated discs with radiculopathy going down my leg. I have referral for epidural L3 and L4. They are insured for 1 million with umbrella. Any idea what I can be looking at? I mean, yeah, I'd have to also know like where you are in a little bit more detail. But if you're in like with a commercial truck and you're not at fault and you have 3 herniations with radiculopathy and you're going to have epidurals. I mean, if it's just epidurals, I've settled epidural cases for like up to 150, I would say. But I would I'm not, a doctor, so I can't give you medical advice. But from what I've seen, epidurals don't really ever solve any kind of problem, because epidurals, what they're doing is they're just putting steroid medicine on the problem. So imagine you have a disc and the disc has erupted and it's leaking and it's touching the nerve. And what they do is they inject medicine that numbs everything. So now all of a sudden you don't feel the pain. But guess what? The medicine wears off and now you feel the pain again. So it's the point of doing it is only like a 30-day, pain relief. It's like taking a Tylenol for a headache. So the better thing sometimes is to do 1 epidural. If that doesn't help you and the pain comes back, instead of doing a second and a third, because you're just numbing the area, go and do like a percutaneous, because there they use a straw and they actually decompress the disc and they remove because remember, the disc has exploded, right? It's like a jelly donut. The jelly inside the donut is now leaking outside the donut, outside the disc, touching those nerve roots. So then what that does is the straw goes in and it removes the leak. And now the disc is a perfect circle, a healthy disc, without any leaks or breakages. So that procedure would make it worth, I think, even 500,000 or more. I mean, here in New York, I don't know where you are. And, like I said, all those factors we'd have to look at. So best to text me. It's 347-566-9595, but I'm happy to chat. And then Curtis says, hey, this is Curtis. I'm going for a steroid injection on the 22nd. Okay, so another epidural. Okay, yeah, you could do that. I mean, epidural, I would try 1. But like I said, if it doesn't help, then maybe like, speak to your doctor, because doing more of them, it just doesn't make sense. It's just it's like saying I have an issue, right? I have this pain. So what would you rather do if you have pain? Just take like Tylenol and it'll mask the pain, or go in and see what's the cause of the pain and actually solve the medical issue, right? Of course, it's better to solve the medical issue. Then you don't have the pain. You keep taking Tylenols, Motrins, Advils, whatever it is, but then the pain just keeps getting worse and worse. It just doesn't make sense. Okay, Arash says, bicycle accident, both SI joint are fused, back, ribs, neck, back pain, seeing a pain doctor, and 10 injections. How much is my case worth? Could it be $1 million or no broken bones? So a bicycle accident with SI joint fusion with pain in the neck and ribs. I mean, I'd have to see like how much insurance they have, where you are, right? It all depends on venue, like all those factors. And then injections, like I know you said 10, but like what type? Are they epidurals or something else? Some injections have a lot of value, some don't. Like trigger points don't really add much value, so it depends on the type of injection. But yeah, I mean, just the SI joint fusion by itself should be worth a few $100,000, I would think. And then Marquita says, in addition to the SI joint fusion and the patella surgery, she also has cerebral palsy and told that she'll need physical therapy for the rest of her life and have decreased mobility. Yeah, no, that's a serious case. Like I said, I think that's a good case. We just have to find the lawyer to help. And then Susan says, I have 3 herniated discs with radiculopathy going down my leg. Oh, no, we did that one. Okay, we did that one. Yeah, that was 2 parts and someone else was in the middle. So, okay, and then, okay, Kay Scottish says, hello, part of my ceiling collapsed on me, not causing major problems, but I have warned the landlord for weeks prior, but 2 attorneys turned me down. Do I just give up? Been to the hospital twice. And she says that it's due to, and then I think it ends. I don't know, maybe it's further down. I don't see the end of it. It just says due to. But yeah, so I mean, yeah, ceiling collapse, is usually a good case because that's the idea, right? If you complained about the ceiling, whether it was a crack or a leak, and then they don't fix it, that's noticed. They knew about it because you complained. And also, it's not like you're not letting them in, right? If you're renting the apartment, they could come in, they could inspect, they should be able to fix it. And they don't fix it, then it collapses. But you need some kind of injury, right? So whatever the injury is, if you're feeling any kind of pain, just get physical therapy, have them refer you for MRIs. You need some kind of injury. So maybe that's why the attorneys, I'm just guessing, but maybe that's why because you said no major problem. Maybe that's why the attorneys turned it down. But just text me. I'm happy to try to find someone for you and help. Okay, and then Sarah says, I slipped and fell on ice and dislocated my kneecap, torn meniscus, 2 small fractures at the end of my femur and a contusion. One lawyer turned down my case, but I signed on with another PI attorney. Would the second lawyer have taken my case if he isn't confident in winning? No, probably not, right? So that's the idea. Like every lawyer has different criteria. Like some lawyers only take a certain type of case. Like sometimes, people come to me and I say, hey, go to this lawyer because they're like the best lawyer. And they've gotten, let's say, like, I don't know, a $35 million verdict. But then look, that lawyer, because he's gotten like $35 million verdict, only takes like $35 million cases. So somebody else might have like a $5 million case and he'll say, no, I don't want that because it doesn't meet his criteria, right? Because he's at a certain level. So it's just like, maybe the first lawyer for whatever reason. And people have differences of opinion. Like there was a case I remember where a guy went into a supermarket. This is many years ago, and he fell. And it was a little tough liability because there was like a puddle, and the lawyer asked him like, well, did anyone ever see this puddle before? And he was like, I'm not sure. And so the lawyer's like, I don't want to take that case because you don't have notice. And he had a serious injury. He had I think a torn meniscus with surgery. So then we took the case, and then, I just spoke to all the other people he was with, and it turned out some of the people were there earlier, and they had seen the same puddle, maybe 30 minutes earlier, because there was like a big family shopping together, like 6 or 7 people. And so anyway, we were able to prove notice, which is a legal requirement, and we were able to settle the case. I think we got over $200,000 for it. And this other lawyer, who's like a really prominent lawyer, big law firm, everyone knows them in New York at least, they said no to the case. So it doesn't really mean anything. It just, everyone has a difference of opinion. But yeah, I think if you slipped and fell on ice, you dislocated your kneecap, you had a torn meniscus, you had fractures. Those are serious injuries. As long as you can prove liability that you slipped and fell because they, as long as it wasn't like snowing at the time, they had time to, remedy and fix the ice, and they should have fixed the ice, and they didn't, whether it's the landlord or the store, whoever it was, then you have liability. Liability is not too complicated in those cases. You can get a weather expert, you can get an engineer or a safety expert. Those are pretty straightforward cases, and you have serious injuries. So I would think the second lawyer probably, as long as the second lawyer is a trial lawyer, you should do fine. You should get a good result. And then Marquita says that her lawyer won't file the lawsuit because she doesn't think she can afford to file or hire experts. She's stalling and framing it like she's avoiding filing for her sake. Yeah, well, like I said, just speak to that second lawyer. I think I gave you one lawyer, right? The one lawyer said no, but then there was a second lawyer. If you want, just call my office or text me directly. You have my number, right? 347-566-9595. And we'll see about that second lawyer. Because the second lawyer, I think, is good also. Maybe he'll take the case. And if he not, we'll find the third lawyer. We'll keep going. Don't worry. We won't give up. Okay, and CC said the other is 100% at fault, 1 million policy. Okay, so that's good. Yeah, if they're 100% at fault, you have a million policy. That's that's a good sign. That's definitely a good sign. Yeah, absolutely. So let's see. Joe says, thanks again for answering all our questions. Could you do some verdicts or settlements for perennial nerve damage. Yeah, sure. I have access again because my verdict search was like being renewed. So while it was being renewed, I didn't have access for like maybe a week. But now I have access again. So sure, I let me write that down. Perennial nerve damage. Let me write it down so I don't forget. Yeah, absolutely. I can do some verdict searches. I mean, I'll do some verdict search videos. I've just been a little busy preparing for this trial and have some depositions coming up. So, but yeah, we'll try to take care of everything. Perennial nerve damage verdicts. And then Sarah says, also, I may or may not need surgery for the town or for the torn meniscus. Okay, yeah. Well, yeah, with surgery, it's worth a lot more, but even without surgery, it has value. And then Amanda says, hi, Arkady. Remember when I asked about how many depositions the defense can request from plaintiff? Well, now we are on our third deposition request, and the case is in New York. I don't understand how they could have 3 depositions. I mean, there has to be a reason, right? Because usually they only have one. And then unless, right, you go and get another surgery, then they're entitled to a second. If you go get another surgery for another body, they're entitled to a third. But they only can have one if everything was done properly. Because if you had all your medical care, you finished your medical care, the lawyer gets all the medical records, sends it to them, right, files the lawsuit, and then they only get one. So I don't understand. Something must be up with that. There has to be a reason. I think they're only limited to 7 hours, too. So it's strange. But if you want to text me, I'm happy to do a consult and try to get to the bottom of it. Try to figure these out. I got to be like investigators, figure out what's happening to Amanda. Okay, Joe says the EMG is saying that my perennial nerve is damaged, causing dropped foot from the slip disc in my back. Right. So that's good because in EMG, remember, with EMGs, you listen to the fibrillation potentials and you actually see the waves and you listen to the sounds. It has sounds and it has like waves. So it's like what's known as objective, like an MRI, right? Because some things are subjective. Subjective meaning like you say you have pain, but how do we really know that you have pain? How do we know you're not like making this up just for like monetary gain, right? To make money. But with an EMG, there's no way, right? Because they put up like pads on you and there's electric currents running through. And like I said, they listen to it and they also see like the electric activity. So if it's confirmed by EMG, that's great. Like I love when I had my CRPS trial, that's one of the main arguments. I put up I made the argument about the sound. I put the fibrillation potentials up with the electrical activity. I'm like, look, this is irrefutable evidence. And the jury agreed and we got like a nice verdict. So yeah, that's good. That's good for you. And definitely have your lawyer argue that. And I remember Joe, I think he has a really good lawyer. I think I helped you, right, find that lawyer. That's a good lawyer that you have. I think one of the top lawyers. So you should be in good shape. And then So Nilly says, my slip and fall accident is about to expire in May of 2025. Can you review my case? Morgan & Morgan took my case, but out of nowhere, they didn't move forward. Yeah, sure. Just text me, 347-566-9595. I'm happy to help. Absolutely. Yeah, let me drop it in the chat so people have my number. It's 347-566-9595. It's also like on every video in the description. I think there should be something in there with the number. Yeah, absolutely. And so we did that one. And then Felipe says, hello, it's me, Felipe. Hi, how are you? He's a really nice guy that we met. Going to be working with one of our new clients. Leonardo says, what is a Blockbuster settlement? Yeah, so a Blockbuster, what they do there is they like have a day, and basically the insurance company invites you, and it's like they just do, let's say, I don't know, 10 cases, 20 cases, 30 cases, and then they have like, authority on each case, and they say, oh, it's a Blockbuster day, come to our day. But really, it's nonsense because they just give you, they're going to give you some money, but it's not going to be really what you're looking for. And, I don't really, because it's like their thing, right? They create the Blockbuster. They want to be like, oh, I'm whoever I am, right? I'm State Farm, I'm Liberty Mutual, I'm Progressive, I'm so fair, I'm doing a Blockbuster day in court. Come to me. You don't have to even go. Like it's their thing, right? The insurance. Well, I do it my way. I say it's Arkady Day. Blockbuster Day. It's Arkady Day. I say, look, here's my number. Pay me whatever. Pay me my number. Pay me $3 million, $5 million. If you don't, fine. Then when I go to trial, it's going to be 10. I don't like the Blockbuster days, but that's their thing. They do that. I guess it's a way for them to get rid of a lot of cases. But remember, they're never going to pay full value. Like if you have $1 million policy, you think they're going to invite you to a Blockbuster day and give you $1 million? No, they're going to give you like 100,000. Everything's like 10 cents on the dollar with those things. And then Kay Scottish says, how do I text you? Yeah, just the 347-566-9595. And then So Nilly says, statute of limitations expires in May 25. Oh yeah, that's tough if it's so soon. But if it's in New York, let me know if we can help you. Maybe I could get it filed for you. If it's in a different state, I could recommend someone quickly so that they could get involved. And then Curtis says, I told the doctor the same thing, and he said it should be a permanent fix. Okay, that's good. And Chance says, currently in the middle of a case with USAA, and my lawyer keeps telling me they are currently talking about settlement. They gave some numbers, but it's taking over a month. What could they be talking about? Well, yeah, that's actually a common question. I'm dealing with the same thing with USAA, actually, for one of my clients, and he keeps texting me every day. Is there an offer? Is there an offer? Look, it's just a process, right? Because look, it's not like I sent them a letter, right? I gave them a settlement opportunity, but it's not like they're going to respond in a day, So I think the opportunity was about to expire, and the lawyer called and he said, can I have 2 more weeks? And now we're in those 2-week extension. But then I found out, like in my case anyway, that what they're doing is they're conferencing the case, and the adjuster is speaking to other people, like their supervisors, to get authority. It's probably what's happening in your case too. Because remember, like insurance, they don't just go like this and just, pay if it's a big amount, like hundreds of thousands or millions of dollars. Everything's done in layers. So one adjuster only has authority for like, let's say 50,000. The second adjuster approves 100. Somebody else approves 250. Somebody else approves up to 500. Somebody else approves. It's like that. And then they have these meetings, and then they sit around the table and they have like 10 people, 20 people, and they all think about ways that they could maybe lower the value or refer it to a new lawyer or do anything, right, except pay you. So they conference these cases. They have to get authority. It takes time, but it's good. The fact that they're talking about settlement is good. And then Mighty K says, can a jury verdict be appealed? It could, but it's difficult. There's certain situations, but it's not easy. And then Sarah says, my personal injury sent me a blanket with a card saying, take comfort in knowing we have your case. Oh, your attorney, you mean? Okay, that's good. Yeah. And then Sasha says, what is the difference between an attorney taking your case and a law firm corporation? Well, it's pretty much the same thing. An attorney just works in a law firm. A law firm is just a group of attorneys. So it's pretty much the same thing. And then Chance says, they never answer me over the phone. I have to personally go there in person to even talk to someone. That's not good. Yeah, they should be answering me. And Susan says, accident was in Florida. I'm just nervous. They will recommend surgery because the epidural will just mask the pain for a short time. If I end up with needing surgery and get it down the road, will that settle for more? Oh, yeah, of course. The surgery is worth a lot more. If you need surgery, that's worth like hundreds of thousands, whereas just if needing surgery could be a lot less. So yeah, that adds a lot of value. And then Mighty K says 60% was put on me and 10% was put on the guy who caused my career to end. So can I appeal the jury verdict, or what remedy do I have, even though my attorney did a good job? You have to ask an appellate lawyer. It depends. I have to look at the record. The record is everything that was said during the whole trial, and then they have to find, whether there are legal issues to appeal. And if there are legal issues, like say the judge made a mistake, then you could appeal. But a lot of the time, they don't like to disturb a jury verdict because unless the jury was like, did something crazy or just didn't follow the law or was against the weight of the evidence or some kind of reason, right? Or if it's an inconsistent verdict, like if it doesn't make sense, but something like that where they put like 60% on somebody and 10% on somebody else, that's more of a finding of fact. So usually they don't disturb that. So, But yeah, it's not an exact science. Unfortunately, sometimes juries do things that, you don't agree with. You think, hey, look, isn't it clear it's this way? And the jury thinks, well, for whatever reason, they find something else. And then Sarah says, what happens if the property owner doesn't answer my lawyer? Well, you just file a lawsuit. If they don't answer, you get a judgment against them. They have to answer. And then So Nilly says, perfect, thank you. You are the best. Oh, you are welcome. And then David says, how often do people settle after a deposition? Well, yeah, usually the settlement is after, just not like immediately after. It's not like you ask the last question and you say no further questions and then you settle right away, right? It's after, meaning it could be weeks, could be months after. But a deposition is like the first like fundamental step because you're finding out what even happened, right? Because before you have a deposition, you don't even know what happened, right? I mean, you know what happened, like he says this, the police report says that, but a deposition is your chance to actually question witnesses and get their story. So yeah, it'll be after, but meaning like, usually a few months after. And then he says, yes, it's in New York. Thank you. Okay, that's good. Cole says, judge dismissed my complaint for no fault in New Jersey law. The lady rear-ended my car. I have Ohio insurance. Can I vacate the order, sue the lady for negligence? Can you explain, please? So judge dismissed your complaint for no fault. I'm not sure what that means. Because like no fault is just in New York, no fault is just like the insurance that pays, like for your medical care. So there's no complaint for no fault. But the lady rear-ended you, so she's at fault, but you have Ohio insurance. And you're asking if you could vacate the order. I'd have to see the order. If you could maybe like text me and then text the order or email the order, I could take a look at it. And then I could maybe give you my opinion or recommend someone for you. And then Achilles says, can you explain summary judgment for labor law 241.6? Yeah, I mean, 241.6 is basically, part of the labor law. There's 240, which is like when you fall from a height or anything gravity related, a falling object, falling worker. With 241.6, it's more like they have industrial codes. And there's a lot of different codes. And they're old codes, usually from many years ago. So you have to find a code violation. And then if you find a code violation in the industrial code, like an example could be, debris in a passageway. You're not supposed to have debris in a passageway. So you're walking, let's say carrying rebar, you're a construction worker, there's debris in a passageway, you step on it, you twist your leg, you fall, now you need surgery. That's a 241.6. You can get summary judgment. You say, look, that's an industrial code violation. It's right in the rules, and they have them in the pattern jury instructions. You find it, you have precedential case law, and you say, look, I tripped because there was debris in the passageway. You take photos of it, you have witnesses, you testify to it as the injury victim. And I just had a case where they got summary judgment on a 241.6. Yeah, so that's all it is. And then now you have judgment as a matter of law. So now the only question for a jury to decide is how much is this all worth? Because liability has been decided as a matter of law. And Mighty K says, got you, appreciate you. Oh, you're very welcome. And Sarah says, what will happen? What will make the insurance company settle prior to trial? Well, like I said, the best way to get them to settle is just prepare the case for trial, do the best, and show them that if they go to trial, they're going to end up paying more, right? Because you're basically showing them what you're going to do. Like I have my experts, I have my human story, my biography, I have my witnesses. Like basically just prepare it for trial. Just imagine you're going to trial, have the lawyer prepare it, full tilt, like as much as they can. Then they're going to be like, oh my God, so if we have to go to trial, they're going to hit us for this huge number. Let me settle, almost that, maybe not as much as you can get at trial. Let me settle for a little less. So you're making them settle by showing them the seriousness of the case. And then Chance says, can you explain what conferencing means? Yeah, it just basically means discussing, conferencing. You conference a case, you discuss it, and so whether it's you conference like a court conference or conferencing in the insurance realm, it just means they're conferencing a case. So basically it's just like all the insurance executives, they sit around a table, and then they might have their iPads, their laptops, whatever, and they ask questions, and they might say, well, the plaintiff is looking for $1 million. What do you think? And then say, well, I think you should offer him 200. And they have all the information, like maybe the verdict search on the lawyer, past cases they've settled with them, the liability, the damages. And somebody else might say, well, maybe instead of paying them $1 million, you have ABC law firm defending this. There's XYZ law firm, and they've defended a case like this last year, and they got a defense verdict. Why don't you switch to them? And they think of anything they can do, except pay you. But sometimes they have to say, look, offer them. It's a serious case, like it's $1 million policy. They want $1 million. Offer them 600. See if they take it. If not, then you might have to go to 700. So it's just basically discussing the case and coming up with their strategy for what they're going to do, how much they're going to pay you. And it's just, a conference, basically, like any conference anywhere. So that's all it is. And then Cole says, what is your phone number and email? I can email you. Yeah, just text me, 347-566-9595. Or you could email me to, I guess you could just email me to contact@866. I'll drop it in the chat, 866 Attorney Law. Yeah, that's an email that goes to my email as well. I have to run because I have to go do something. Sorry I started so late, but we got about 40 minutes in. That's not too bad. And I don't see too many more questions, but maybe we'll try to do another one tomorrow, maybe during the day. And definitely next week, like Monday, Tuesday, I'll do a few more. I wanted to do a few of these, but like this week got a little busy, but yeah, maybe tomorrow. Let me know what time is good for you guys. Maybe tomorrow, maybe a little earlier, like 4 or 5 o'clock. Although it's Friday, I know people don't want to be ready. But, if you have questions, I want to answer them. Okay, everyone, thank you so much. Please like and subscribe to our channel. Let us know what questions you have. Let us know what, what other topics you want to see for videos, and all the best, everyone. Okay, have a great night. Bye-bye.